Welcome to The Explainer. Today, we are tackling a skill that is absolutely fundamental for any aspiring Queensland barrister, mastering the power to amend pleadings under Rule 375 of the Uniform Civil Procedure Rules. You get this right, you can save your case. But if you get it wrong, well, you could be in the tough spot of explaining to a judge why you've just wasted everybody's time. So picture this. You've spotted a mistake, or maybe a new argument, or worse, a fatal flaw in your pleading after you've already filed it. And you get that sinking feeling in the pit of your stomach. Is your case doomed? Well, not necessarily, but how you handle it is absolutely critical. So we're going to break down how the court approaches this and the key principles you really need to master for your bar exams. Okay, so here's our game plan. We're going to start with the foundational rule, the source of the power itself. Then we'll dissect it piece by piece. After that, we'll look at the massive philosophical shift in the courts, from the old case of jail holdings to the game changer, Aon. We'll get a grip on the modern test, and then we'll wrap it all up with a summary that's perfect for your exam notes. Right, first things first, where does this power to amend even come from? Let's go straight to the source. It all flows from one place, Rule 375. And the key phrase to remember here is wide discretion. In theory, this gives the court the flexibility to allow changes to pretty much any document at almost any time, all to make sure the real issues get sorted out. But, and this is a big but, as we're about to see, that discretion under Rule 375 is definitely not unlimited. The way it's used today has been dramatically reshaped by modern case law. Okay, let's get into the nitty-gritty. We're going to break down the specific sub-rules of Rule 375. You absolutely, 100% have to have these down cold for the exam. Your starting point, every single time, is Rule 375, Sub-Rule 1. Just burn that into your brain. Rule 375-1. This is the big one, the general catch-all power. You can think of it as the engine room for the whole rule, right? It gives the court that fundamental flexibility to allow or even direct amendments at any stage of a proceeding. Next up, and this one is crucial, is Rule 375, Sub-Rule 2. This rule is a big deal because it completely overturns an old, really rigid common law idea that a plaintiff had to have a complete cause of action the very moment they filed. Rule 375-2 says, nope, we can fix that. It lets you amend a case to include a cause of action that actually popped up after the whole thing started. A very handy tool to have in your back pocket. Now listen closely to the change in wording here because it's a key distinction for your exams. The first two sub-rules use the discretionary word may, but Rule 375 Sub-Rule 3 says the court must allow the amendment. So under Rule 375-3, if you've just made a simple mistake in a party's name, what the law calls a misnomer, fixing it isn't up for debate. It's mandatory. And finally, we get to the important fine print in Rule 375 Sub-Rule 4. Think of this as a big flashing signpost. It tells us that this broad power in Rule 375 has a major boundary. It's all subject to Rule 376, which lays out very specific, very strict rules for when you're trying to amend something after a limitation period has expired. That's a whole other can of worms, but just remember, limitation periods change everything. Now, to really understand where we are today, we have to take a step back in time. For a very long time, the way judges thought about amendments was incredibly liberal, and it was all shaped by one famous case. And this quote from the High Court in jail holdings was the guiding star. The whole philosophy was pretty simple. If there's an arguable issue, it should be heard, period. The court's job wasn't to act like a school principal, punishing people for mistakes. The thinking was that any problem caused by a late amendment could almost always be fixed with a costs order. Just make the party who wants the change pay for the trouble. Simple, right? But as you know, the world of litigation was changing. Courts were getting clogged up, and this new philosophy of case management started to take over, which led to a massive high court decision that completely changed the game. And this is where Rule 5 of the UCPR comes into play. This rule, and ones just like it, all over Australia, basically put it in writing that justice isn't just about getting the right result in the end. It's about getting there efficiently and without breaking the bank. It put undue delay and expense right up there with legal mumbo-jumbo as things to be avoided at all costs. The facts of the case, Aon Risk Services v. ANU, show exactly what the problem was. So, the Australian National University sues its insurers, then later joins its broker, Aon. Years go by. The whole thing finally gets to trial. Then, on day 3 of a 4-week trial, ANU settles with the insurers and then tries to adjourn everything and completely rewrite its case against Aon. You can just imagine how the judge felt. This was the moment that triggered a seismic shift in the law. So the High Court's decision in Aon was huge. It completely reshaped the landscape. It actually overruled JL Holdings and switched the test for amendments from a pretty simple principle to a much more complex, multi-factor balancing act. I mean, just look at the contrast here. It's night and day. Under JL Holdings, justice was all about hearing the parties' claims. After Aon, a just resolution explicitly includes the goals of Rule 5, speed and efficiency. The court said, hey, just throwing costs at the other side doesn't always fix the problem. And, this is the big one, there is no right to amend. It is a discretionary privilege, not an entitlement. So what does this mean for you? Well, it means when you're on your feet, asking for leave to amend, you now have to address all of these things. How late are you? Are you going to blow up the trial date? What's the prejudice to the other side? And here's the kicker. What is your explanation for the delay? The High Court in Aon made it crystal clear that if you can't give a good explanation, that alone can be fatal to your application. But hold on, this doesn't mean you can never get a late amendment. The nuance here is really important. In cases like Samras, the Queensland courts showed that the Aon principles are applied with some flexibility. Look, an amendment you ask for while everyone is still sorting out the pleadings, way before a trial date is even set, that's going to be looked at way more favorably than when you try to pull on the courthouse steps, like in Aon. The stage of the litigation is a massive factor in this whole balancing act. All right, let's pull all of this together. Let's build a practical framework that you can take straight into that exam room and just execute. Here it is, your 5-step playbook for any problem question on amendments. Follow this and you're golden. Step 1, identify the power. Start with Rule 375 and be specific about the subrule. Step 2, characterize the amendment. What are we actually dealing with here? A typo? A whole new case? Step 3, apply the Aon test. You have to say it. The modern test is the balancing act from Aon. Step 4, weigh the factors. Go through them. Delay, explanation, prejudice, wasted costs. And finally, step 5, conclude. Based on all that, advise on the likely outcome. Easy as that. Okay, if you remember absolutely nothing else from this explainer, remember these 5 points. Seriously, these are the core of the modern law on amendments in Queensland. Rule 375 gives the power. Rule 5 gives the philosophy. Amicon sets the test, and a good explanation for any delay is pretty much your golden ticket to getting leave from the court. And that right there is the ultimate question you have to be ready to answer. It is no longer enough to just stand up and say, my client has an arguable case and we'll pay the other side's costs. Now you have to persuade the court that granting your application, with all its consequences for delay and expense, actually serves the broader interests of justice as a whole.